attorney if you are an owner. The chat function in the Zoom is intended for questions or requests for clarification on the topics that we discuss. The commentary or any of the things that are in the chat are not legal advice. If you're not sure how to mute yourself, there's a little microphone somewhere at the bottom of your screen. If you could keep yourself muted, it just kind of cuts down the background noise for us, but feel free to unmute yourself if you need to ask a question that you're not able to put into the chat. We have a fairly small amount of questions today, so we may have time at the end for additional questions that weren't submitted in advance. Please feel free to put those into the chat as well, and we'll try to get to those at the end of our pre-submitted questions. A reminder that June 9th is Virtual Law Day, which is just fully online law day through the WSCAI, and 2 of our attorneys are speaking at that event, so they hope to see you there. A reminder that next week there will not be a Q&A on May 27th. That is the week of Memorial Day, so have a nice week off, and we'll see you after. And a final reminder, if you have changes that you are wanting to see in the community association statutes, primarily in WUCIOA, which is what is being amended mostly now, please submit them to the WSCAI Legislative Action Committee. They're looking to propose some changes during the upcoming legislative session in winter of 2026. If you are looking for more information on the committee, you can look at the WSCAI.org website for more information on that and how to request updates on the Monday morning minute from the Legislative Action Group. Did I miss anything, Ken? Are we ready to get started?
I think we're good.
Okay. The first question that we had submitted in advance says, SB 5129 I think it just is referring to SB 5129, does the secret ballot and counting of them come into effect as of January 1st, 2026 for any condo that was organized under the Horizontal Properties Regime Act? And the short answer to that question is no. The secret ballot provision of WUCIOA that you are talking about, which was enacted in the 2025 session and is part of the statute now, only applies to WUCIOA communities until 2028, when all of the communities will become WUCIOA, what is called WUCIOA for all. That's January 1st of 2028. The section that you're referencing is in section RCW 6490-455, subsection 9. And we have had lots of conversations in prior Q&As about secret ballot provisions and discussion on those topics. So feel free to go to our YouTube channel and search in the with the little magnifying glass the word secret or ballots, secret ballots, and you should be able to find prior conversations on that if you have more in-depth questions related to that topic. When we were talking before this meeting, we discussed that some clients we have seen are declining to reveal how owners are voting based on privacy concerns related to different parts of the record statute. So if your question is related to whether or not you should be disclosing ballots or whether they should be secret, that may be more of a records related question than it is a secret ballot question. Anything you feel you should add there, Ken?
No, I don't know why the legislature was very specific about the secret ballots in WUCIOA and did not also amend the voting statutes for the others. And it may be because at the time they were doing WUCIOA for all, the original transition date was, a couple years before 2028, and they didn't feel like they needed to modify any of the others. Most of the statutes which they wrote last year affecting records or voting or anything else, they did modify all 4 of the statutes to make sure that change took effect. So the second question is, what are the procedures regarding 6490-505, which is rules, and for changing rules in a comment period? Does the board send out the new rules to all and provide a 30-day comment period? If the comments come in, does the board review and decide those in an open board meeting? And what will change, if anything, from the original rules they sent out? So I guess the second part of the question is, if the board decides to make changes to the rules as a result of owner comments, does the board then need to send those revised rules out to the membership again for another 30-day comment period? So we'll offer, this is a confusing question to us, but we're going to try and respond anyway. 505 in UCIOA does require that you give advance notice to owners of proposed rule changes. It does not state a 30-day period. It just states that there has to be an opportunity for owners to comment. We think that the 14 days notice that you're required to give in advance of a meeting, where you might include on the agenda the rules modification, would probably be adequate. And the comments which you would take from the owners could come both in writing, which would then become part of the board packet for review, or they could be made during the 15-minute owner comment period at the beginning of the meeting where the board is going to address the rules changes. Whether or not you would need to send the rules out a second time if they were modified, I think is really going to depend on how far the rules which you're changing stray from either the proposed or the existing. So if you were proposing rules with quiet hours of 10 o'clock at night, and then the comment period suggested that you allow for 11 o'clock on Fridays and Saturdays, I think that the board could just make that change. And then when they send the rules out after the meeting, that would probably be adequate. But if you were to make a really significant change to the rules, like decide you're not going to allow any dogs, I think that you would have to give owners an opportunity to comment on that instead. So it's going to be kind of dependent on the circumstances. It may also depend on how much of a pushback you expect to have from the membership in response to a proposed rule. So we've seen a lot of pushback on rules for things like parking, and some people get really passionate about that. So if you are sending out a set of rules and then you modify them and you know it is a hot button for your client, your community, I'd suggest you send it out again and make, delay by a month the decision to incorporate that new change. So again, there's no stated method of accepting or reviewing comments. I think you need to use some common sense. If people are sending in emails or letters, then consider those. If you have a comment period beforehand, you can do that. You could also allow a special comment period just when you are discussing the proposed rules, so that your board could be fully informed about how your members feel about the proposed rules. So, the outline of the steps is you send the proposed rules out with enough time for people to comment. They have to be adopted at a board meeting. And then after they've been adopted, you have to send them out again to all the owners, so the owners have formal notice of what the new rules are. A couple other things that are in the statute worth noting. One is that the internal business operating procedures do not need to be adopted as rules. So if you have something like a collections policy or a investment policy for reserves, or even an ACC policy about how you're going to review changes that are requested, those are policies which you don't have to follow the same process to get approval from your membership. And then another provision that's actually written into the statute is that every rule must be reasonable. And of course, reasonable is not a well-defined term, but it's going to be something which, if you ended up having to really define it, it's going to be done by a court after the fact. Did you have anything you want to add, Lisa?
No, I guess maybe yes. The 30 days may come from, sometimes if we're the ones drafting a policy or rules, we may tell you to not have it go into effect for 30 days or for some amount of time that is reasonable, after it is signed into, after the board approves it finally. So that may be what that is. I don't know where the 30 days comes from, but yeah, as Ken said, just a reasonable notice is all that's required. Next question. Regarding our association's legal requirements for fulfilling member records requests, specifically, I'd like to understand the permissible costs the association and/or management can pass on to a member who requests to inspect or receive copies of association records. Is management permitted to charge members a fee for the labor and time required to produce these records? And can a fee be assessed for management's time while a member is physically reviewing the records in the management office? Can members take photos of the invoices? And are there specific legal or practical reasons why management would not simply provide these records via email? First off, I'll say that you don't say what kind of association or what statute your association is organized under. So I'm just going to use the WUCIOA records statute for the purposes of this conversation. That's 6490, 495. You can look up RCW 64.38 and the word records, or 6434 records, whatever your community is, and you should be able to, it'll bring you right to your community's records statute. There are slight changes between the WUCIOA statute and the other statutes, so you will want to make sure you're looking at the one for your community. None of the statutes say how much the association can charge when an owner makes a records request. What it says is in section 5A, an association may charge a reasonable fee for producing and providing copies of any records under this section. So I think, a reasonable fee would be, what are the costs of copying those records if the person asks for hard copies, and how much time is it taking for your manager to produce that, or the person who's doing it to produce that. That would also include the cost of supervising an owner who comes to an office to review the records at the management's location or at the place where the records are being stored. The question of, a unit owner is entitled to receive a free annual copy of lists of owners of the association. So we'll talk a little bit about this later with another question. So if the request is for a copy of a list of all owners, that is something that the owner is entitled to a free copy of annually, and you can't charge through reasonable charges to those. They are also entitled to pre-foreclosure information. So if they have been sent the pre-foreclosure notices under the statute that we've talked about a lot in the collections arena, those things they are entitled to receive as well. The statute also does say that the owner is entitled to copy records. So if your question is, can they take a photocopy of invoices or other things? Yes, they can, subject to potentially an exception for invoices that may contain, attorney-client privileged information. You'd want to make sure that that is not viewed by the owner and copied by using photocopy or their telephone or whatever they're using for that. And I think your final question about whether it makes sense to send things electronically, absolutely. I think that is a great way to save both time and money. Some associations have most of their records in a repository online, and owners have access to the things that they are entitled to have access to. That would be a fantastic way to provide the information. It is a less onerous research and management for either the manager or the board president or secretary, whoever is responsible for that. So that would certainly be a simpler and less costly way to provide the information to an owner who requests it. Anything you want to add to that, Ken?
Yeah, a couple things. One is the only real difference between the record statute under WUCIOA and the other three relates to the secret ballots, which we already discussed. So WUCIOA was amended so that you have to redact or remove information that would indicate how people voted in elections or for amendments to their declaration. There is a requirement in the statute to redact information. There's a difference between redacting information and withholding documents. And so if you are required to produce a record, and we'll use the ballot as the example, you would have to redact out the information that would indicate how an owner voted, but that doesn't mean that the ballot otherwise wouldn't be something which could be reviewed by a requesting owner. So the time that's involved may not be so much collecting the documents because you may have them fairly simply in an electronic form, but it may be trying to find a way to withhold the information you are required to withhold. And there's a long laundry list of things that have to be redacted out. And that's, where the biggest concern comes. So, we used to have clients who would have banker boxes full of records. And so the question was, well, who would go through all of the banker boxes looking to see if there's information that was either privileged or too private that it could be shared before you allowed the owner to come in and look through the same banker box? And it would be the cost of that person going through the information first that you would be looking to assess. You can't probably just pick a flat fee because the amount of time involved is going to vary by the records request being made. And, again, reasonable is something that gets decided by a court after the fact. And we would generally recommend that you err on the side of something that appears reasonable to a normal person. We had a request last week for a client, and the manager's estimate was $1,300 to review the records based on the request. But the owner was asking for 20 years worth of records, so I don't know that that was an unreasonable estimate. And, if you're concerned about what you might be charging, you can certainly choose to charge less if you're trying to just satisfy an owner and be done with the dispute. You can also get advice from an association attorney to help you decide whether or not it's reasonable. And we do think that you can decline to provide the records if the owner does not agree to pay what would be supportable as a reasonable fee. Okay. Anything else you want to add, Lisa?
Nope, go ahead.
Okay. So next question is, I have a question about 6438025 regarding membership ratification of a budget. So my first response would be 38025 has nothing to do with ratification of budget because the only statute that applies to ratification of budget or special assessment is 649525. And that has been true since 2018. So when we finally get to WUCIOA for all and you throw away your Homeowner Association Act notebook, we might get that message across finally. But it is only the budget section of WUCIOA that matters for every community. So continue the question. My interpretation is that the membership must meet to vote on the budget. Can the voting be done by mail or by a mail-in ballot? I'm confused what must happen in a timeline involved. Please explain in plain English. I do not understand the phrase whether or not a quorum is present. If ballots are mailed out to the owners, would that be a quorum? Can a board operate if no budget membership votes were conducted for years? So that last question will address, I'm going to address that one first. Can you operate if no budgets were adopted for years? If you've been collecting dues and paying your bills, clearly you've been operating. The statute provides that the last budget that was approved continues in full force and effect if you do not hold the meetings or get the ratification. And Lisa may correct me on some of this as we go. So if you have not been holding proper meetings or getting the ratification done, our recommendation is start doing it now. And if you run into problems with people complaining about the past, then seek out a qualified attorney to help you sort that out. There are different ways of doing it, and part of it is find a solution that your members can accept and you can accept. In terms of the process, we do believe you have to schedule a meeting. Only one person has to show up for the meeting. You do not need a quorum for a budget ratification meeting because the vote is specifically whether or not to reject the budget, not to approve the budget. So The reason a quorum is irrelevant is that if you don't get a quorum to show up and reject the budget, it is automatically ratified. It is okay to use absentee ballots or send ballots out in advance that people can then submit instead of showing up for the meeting. And the absentee ballot section is in the voting section of your statute, not in the budget ratification section. But it says that if the association prepares ballots and sends them out to owners, and the owners turn them in before the meeting, those count towards quorum and those votes would count. So if you sent out ballots for your budget ratification meeting, those would be counted at the time of the meeting. You would still hold the meeting and you would still ask if anyone wanted to reject the budget. If you don't have a quorum or you don't have 51% of the membership show up to reject the budget, then there's really no way for the process in the statute to reject the budget. Did I cover everything, Lisa, or do you have something you want to add?
No, I think they just asked for the actual specific steps, and so I would just say they're laid out pretty clearly in the statute, but it's board approves budget. Within 30 days, board sends it to all the unit owners and sets a date for the ratification meeting. That has to be within 14 to 50 days from when that was sent. At the meeting, you ask if anyone has a motion to reject the budget. If nobody does, or the vote is not carried by, as Ken said, more than 50%, or that it could be higher if your declaration has a higher percentage for the budget, then the budget's ratified. That's it. There should not be any, should not be any questions for a vote in support of the budget, or a motion to approve the budget is purely a motion to reject the budget. Those are the steps, and they're pretty, if you look at the section that Ken reminded us, 649525, it's laid out pretty carefully in there and pretty clearly in there what a board needs to do to get a budget ratified.
And the rejection percentage is of the total ownership,
That's right.
not the people that show up for the meeting. It's not a percentage of the quorum. It's the total membership.
And the budget ratification hasn't changed in the last few years. And we did, I think Ken and Valerie maybe did a primer on this on our YouTube channel, I'm going to say 2 years ago or so. And that's still very helpful. So if you're looking for a real discussion of what to do and how to do it, that you can look on our YouTube channel for that. I think it was less than an hour conversation about that. Do we have any, we don't need to talk about the quorum question, Ken, because that isn't a relevant issue for this particular question. The owner or the person had asked.
Yeah, I think we're done with that question.
Okay. Next question, the final one submitted in advance, is our annual meeting is coming up at the end of May 2026, and I need to email the property manager and board to request a list of email contacts for all of the owners. I recall at a previous Q&A Zoom, Ken or another attorney stated that the HOA board is required to provide this information unless a unit owner has specifically requested that their contact information be kept confidential. Can you please confirm my understanding and provide the RCW citation? Again, we kind of talked about before the records sections and which that each community has its own RCW section, and as Ken indicated, the only slight change is the secret ballot provision. But if you look at RCW 649495 subsection 5B, a unit owner is entitled to receive a free annual electronic or written copy of the list retained under subsection 1C, and we can talk about that, of this section from the association. And 1C says the names of current unit owners, the addresses used by the association to communicate with them, and the number of votes allocated to each unit. So that is the list that an owner is entitled to request once a year from the association. I think the key there is used to communicate with would be how does the association talk to or communicate, not talk to, how does the association submit notice to an owner? If that person has opted into email notification, then the email address would be the relevant address to provide. If they only receive their notices from the association by mail, then that would be the address to provide. The requirement or the ability of owners to restrict access of their electronic or email address from disclosure under this list is unique to WUCIOA. It is not in the other records statutes. So if your community is not a WUCIOA community, that requirement of this under the statute to restrict an email address if an owner requests it is not there. We don't have any case law to know whether or not that has been tested in the other statutes because the language is not there that specifically authorizes a community or requires a community to restrict access to that email. So if your community is a WUCIOA community, has and uses email addresses for formal notice to the owner, and the owner has not requested that their email address or their email address be kept confidential, then the email address must be included in a list of addresses provided to any owner who asks with their annual request for a list. Hopefully that wasn't too convoluted. Anything you want to add to that, Ken?
Well, just sort of summarizing a different way,
Okay.
there is no right of an owner to get every email address for every owner. There is a right for an owner to get email addresses if that is the method that the association uses to give them formal notice, like sending them the notice of the budget ratification. Otherwise, your entitlement as an owner to get every owner's address is limited to the mailing address which the owner has provided to the association, which may or may not be the actual unit address. And then under the statute, you're entitled to the list of owners and the address used to communicate once per year for free.
Do we want to go through the questions submitted in the chat first and then?
No, I think we're going to go ahead and talk about this other thing first.
Okay.
So there are a few changes to the statutes for community associations which take effect on June 11th, which is now rapidly approaching. One of those changes relates to House Bill 1501, which kind of snuck into the legislature. We don't know why. It was certainly not something pushed by the Legislative Action Committee. But the new law is very specific to a requirement of associations to provide substantive responses to questions from owners that are submitted by certified mail. Okay. So the law requires a substantive response, and it defines what a substantive response is. It has to be provided within 30 days, with some exceptions, of a written request received by certified mail. And it applies to all communities. And then it also limits the number of requests that an owner can make by certified mail to one each 30 days. And it does not limit the number of questions which can be made in that request every 30 days. So it's not one question every 30 days. It's one request with as many questions as they want every 30 days. So again, this is House Bill 1501. If you were to type into Google EHB space 1501, the E is, I think, for the term enhance, which means that the bill was modified as it was discussed by the legislature. Okay. Now, we have a number of clients who are in a panic about this new law because it is requiring substantive responses within 30 days. And we're not exactly sure why the statute is a concern to some of our clients. It doesn't change the statute related to records requests in any way. So if you're a WUCIOA community and you're required to produce records within 10 days, you still have to produce those within 10 days, even though you may have 30 days to respond to the request. This obligation to respond does not occur unless you get a request by certified mail. And the certified mail is going to come to wherever your official address is for your association. So that would normally be who I would see on the Secretary of State's website for your community. So it might be the management company that you use. We do have some clients that have registered agents, and then clients which don't have management companies may have the home address for one of the board members. So you'll want to make sure that you've updated to have the correct mailing address, because it has to be something that be delivered by certified mail. You're not allowed to use a post office box for your registered agent for Secretary of State. The statute itself is, I'll say, relatively short. It condenses to essentially one page, and we are now including it when we rewrite bylaws because we want to make sure we're covering everything. But we did have a client who used ChatGPT to give them suggestions on how best to comply, and it produced a 10-page document on all the different policies and procedures and definitions that a community could adopt in order to use best practices. Okay. My expectation, and I'm pretty sure the expectation of the legislature, was that most of the questions that are going to be asked are going to be relatively straightforward. So a substantive response to why are we not allowed to have dogs would be a citation to the declaration or rules which say you can't have dogs. It doesn't have to be a long discussion about why you don't allow dogs, just a citation to the section of the governing documents that controls that question. If the question was about why you chose a particular contractor, then the answer should be something like the board discussed and evaluated the bids from the different contractors and decided that contractor X was the best choice for the community. If you chose based on price, you could say that. If you chose based on the expected performance, you could say that. So for the most part, the substantive decisions which your board is making just need to be disclosed instead of just giving the fact about something. And I'm sure there will end up being litigation over this because some clients will not want to provide the substantive answer because they think it's going to offend or for some other reason. But you're just going to have to do the best you can in trying to comply and sort of see how it works out. So the 30-day has some exceptions. You're allowed to get more days if you are needing to have a meeting of your board, but it does state that you can only do that if you're having regular monthly meetings. You're allowed to have more days if you need an opinion from an attorney, accountant, engineer, or some other professional, because the statute provides you more days if you're getting that expert opinion. If you are acquiring an expert opinion, I would recommend that you be telling the owner within 30 days that that's what you're doing. And so when they would expect to get the substantive answer which you were required to give. So it's certainly a statute of interest. It's one which we are expecting some difficult owners are going to weaponize. There's no question that that can happen, but they can weaponize a whole lot of the other existing statutes as well. And so mostly I want people to be aware that this statute is taking effect in June and sort of be prepared. The ChatGPT 10 pages was recommending that before June 11th, every client take a bunch of steps, including, confirming the mailing address for owners to send the certified mail, adopting policies for review, adopting policies for when they would get expert opinions, etc. I don't think most of that is necessary, but if you get one of these requests, it is going to require some fairly direct attention and prompt attention so that you can comply. The statute has a specific attorney fee recovery provision in it, so that if you are refusing to comply with the new statute and an owner were to sue you to recover their attorney's fees, the statute specifically provides their right to do that. Is there anything you want to add about this, Lisa?
I don't think so. I'm always just interested in obsession with certified mail, but that's a topic for another day.
Well, it is interesting because so much of the rest of the statutes are moving towards electronic notice and defining records specifically to include emails and other electronic communications. And this one instead went backwards and said,
Right.
well, certified mail gets a special response.
Yeah. But no other comments. Chelsea, do we have any questions in the chat that we should answer? Oh, Chelsea's working on muting. There we go.
Okay, I have in the chat. If you have time, what RCW can I refer to that provides information about violations and fines? Does WUCIOA have a cap on fines per incident?
So the authority to assess fines comes in the section of every statute which is the association powers. It's usually one of the first couple in that statute. I think under the Condo Act, it's 6434-304. I don't remember exactly. I think under WUCIOA it's 6490-405. But you could also just type in your statute number 6490 and then rules, and it might pop up.
Yeah,
Under
or
WUCIOA,
powers.
there's a whole other section on rules, so it's not going to pop up first, but it is written in the powers section. The statutes all say that you are allowed to assess reasonable fines after notice and an opportunity to be heard, in accordance with a schedule of fines provided in advance to the owners. So there is not a specific maximum fine. I can tell you I have had fines come into my office that I looked at and immediately thought were unreasonable. So I had one come through recently where there was an $800 fine for a garbage can having been left out overnight. I have seen fine schedules where the association doubles the fine every time it occurs. So if it starts at $25 and goes to $50, that may be okay. But if you're up to $400 and then go to $800, or from $800 to $1,600, I'm going to have a really difficult time as your attorney supporting that that is reasonable in court. I would also offer that a lot of people they start to focus on recovery of money instead of compliance with the rules. And I am personally a fan of waiving fines if it gets you compliance with the rules. So if you want the person to keep the garbage can in and you've sent them a fine, whether it's $50 or $800, and they ask for an opportunity to be heard and they tell you how it was a one-time thing and they're going to make sure that they don't do it again, you're getting compliance, and I would advise you just waive the fine, and because that is your ultimate goal. Fines are not a revenue source. Fines are supposed to be something to encourage people to comply. Okay. And we have some communities which have a single blanket fine schedule. We have other communities with really complex, different levels of fines for different levels of infractions. We have a number of clients who want to write into their rules that certain violations come with immediate fines with no opportunity to be heard. And when I see that, I have to tell them that I cannot enforce that. And if the fine comes in on a collections matter, Lisa cannot collect it for you. Okay. So none of the statutes allow for a fine to be assessed if you've not given notice and an opportunity to be heard. Okay. So we recommend that that's included in the first and second fine letters, at least if it's not included in every fine letter. So you don't assess a fine and offer an opportunity for an appeal. You tell them that you're going to assess a fine in 10 days and they have an opportunity to request a hearing. If they request a hearing, you do not assess the fine. You wait until after the hearing, at which point the board is able to make an informed decision about whether they should or should not assess the fine. And the board can always choose to assess a smaller fine. So even if your fine schedule says it's $800, you could, as a board, choose to assess a smaller fine for whatever reason you think is appropriate. Anything you want to add, Lisa?
Just that as a collections attorney, that is probably the main thing that I have to not collect as part of a collection action are fines, because the due process requirements are not met. So if you have questions about whether or not your attorney can help you enforce compliance fines, ask them to look at your letter. I'd say a huge percentage, more than 50%, do say appeal or don't, or say the fine's going into effect right now instead of after the hearing. There are lots of issues with a lot of the fine letters we're seeing, so I would certainly recommend having someone take a peek at those if you're intent on collecting those fines and
Yeah,
getting
we have
compliance.
seen some management company software which have built-in fine letters that are not based on Washington law. They may be good in other parts of the country, but they need to be edited to comply with Washington law. Chelsea, you have any more?
What are best practices around opting out of physical mailings and opting into electronic notices? If an owner doesn't like the electronic method, do I have to provide notifications in another way?
If an owner does not agree affirmatively to receive electronic notice, you are required to provide it by mail or personal delivery. It's not an option for the association. It is an option for the owner.
Yeah, we talked a lot about that when that first came into effect a couple of years ago. So you can always search electronic notice and on how to get someone to opt in or what you need to keep in your records. But for sure, if an owner's saying, don't send me electronic notices, you need to send them by mail.
And certain things we would recommend you send by mail, even if you are not required to because they've agreed to electronic notice. And one of them is, I would say, collections notices and fine notices, because you want to make sure that they get it and they may not be paying attention to their email.
And particularly with the changes to the collections portions of the statutes, some things are required to be mailed. So you definitely want to make sure those are being mailed.
Right. And some things are required to be mailed not just to the owner at their requested address, but also to the unit.
That's right.
So lots of new notice provisions for collections that the legislature has adopted over the last 5 years.
Yeah, I guess the short answer is that you should not assume everyone gets electronic notice. Any others, Chelsea?
When should we begin adopting WUCIOA? Do we need to wait for the deadline?
Well, parts of it you have to have adopted already. So you have to have adopted the budget portion. You have to adopt the meetings portion, which is section 445, and because that one took effect January of this year. In terms of the rest of it, I would say that you would be safe in adopting most of the provisions of WUCIOA as a practice now, meaning you can try and do secret ballots now. You can try and do voting by the procedures, in WUCIOA now. That the risk is relatively low of doing everything according to WUCIOA now. If you're saying in your question, really, do we have to amend our declaration to adopt WUCIOA? That's a different question. And there's not an obligation to actually rewrite your document to match WUCIOA. There's only an obligation to follow the statute where it conflicts with your declaration. we have noticed a substantial increase in the number of communities that are looking to rewrite their documents and adopt UKIOA now. I would say we are at, double the number of clients rewriting their documents now. And my guess is that we're going to see a substantial increase at the beginning of 2027 because people are going to feel like they need to adopt it in 2027 because it's going to take effect in 2028. So is there a best time? I would say it kind of depends on your budget. We have heard rumors that several of the other law firms are having challenges in producing documents in a timely fashion for their clients to adopt revisions. And part of it depends on whether you want to make other kinds of changes to your documents at the same time as you adopt UKIOA. If you're not looking to make any other kinds of changes, then I'd say there's less of a push to rewrite your documents or adopt UKIOA. If you are interested in making changes, as many condos are with handling insurance deductibles, or if you want to clarify the maintenance obligations for the townhome or condominium community to better clarify what owners pay for versus what the association pays for, those are reasons to also adopt UKIOA and amend your documents. Those are the two biggest things which we're seeing as substantive changes to condominium or townhome community governing documents. Single family home communities have fewer, sort of revisions to their documents that would come from UKIOA. And so they may have less of a priority. And I guess one of the things really is people adopt UKIOA with a new document. They restate their document because they're trying to avoid confusion. Kind of like we had today with people still looking at budget procedures from a statute which was revised 8 years ago. And so if they rewrite their CC&Rs or their condo declaration, then the document they're referring to is much more likely to match the statute, which is they're required to follow. Any other thoughts, Lisa?
Nope. Any other questions, Chelsea?
I have a board that is rules and regulations, but no escalation process. They want to send out a letter to owners that they will receive written notice to take care of their decks, which are owner responsibility, and that they have 30 days to correct the issue on the board, or the board may arrange for a maintenance to be done and charged back to the owners. What are your general thoughts on their process or things to consider?
Well, this is really specific to what the declaration says in terms of both the, who has the obligation to maintain the decks, and then also the right of the association to perform the work if it is an owner's responsibility. And because so many clients get those two things wrong, I don't want to attempt to answer that question on this forum.
Historically, the Architectural Committee meets via Zoom to review and vote on requests. Declarations state requests needs to be responded to in 15 days. Now that all meetings where a vote is made need to be public, do we have to modify declarations to change this response period so that votes can be made during quarterly HOA meetings?
Well, I'll say to some extent, we're also getting into, I really wish I could see the document. If the committee is making decisions that are exercising board powers, and it sounds like maybe it is, because if the committee is approving or rejecting an ACC request, that is a board power, then those Zoom meetings should be held as open meetings. The owners would have the notice of those meetings and an opportunity to comment at the beginning of the meeting. And then the committee could make the decisions. you should in theory also then be providing the 14 days notice that's required by statute, though there is a 7-day notice provision for unforeseen circumstances now written into the same statute. Quarterly doesn't work particularly well in my mind for requests for ACC modifications, partly because owners will be upset at a long delay, and partly because if your declaration did require a decision within 15 days. And we don't really know how the courts would interpret a provision that says you must respond in 15 days when it also then requires that you have to give notice and at least 14 days for owners before you could make a decision. So that is something where I might recommend you modify your declaration in order to provide a process which you can perform in compliance with the new statute. So, any thoughts, Lisa?
No, I think that makes sense to me. Any other questions, Chelsea? A couple more minutes.
If they email the manager and tell them to use email, but will not fill out the form that the manager has asked members to fill out, is the email from the owner sufficient?
And I think this ties to one of the other questions I saw maybe coming in on, what statute governs.
The short answer is yes.
Yes.
Because the definition of a record includes an email that you can print out and save. And all you're required for the electronic notice authorization is a record. So if the owner sends an email, save the email as the record which is authorizing notice electronically. You do not need to have a paper form or a DocuSign or anything else like that.
And to find your statute, just search RCW 6490 and the word notice, or 6434 and the word notice, and you'll find it. For example, WUCIOA is under section 515. It very clearly lays out how notice is to be given to owners and how an owner could opt in to electronic notice, and cites Ken's
So
example.
we have seen some clients become so rigid in how they want the request to be made that owners don't comply. And I would suggest you be as flexible and generous as the statute allows in order to have a larger number who have accepted electronic notice.
And I think we talked about before too, having something that's you have to actually have them opt in. You can't have it be an automatic electronic notice unless you opt out. So make sure that the owners are opting into electronic notice. Anything else, Chelsea?
Nope, that's all I've got.
Okay.
Great.
Well, thank you, everyone. And next week we have no Q&A. And I guess maybe, yeah, we'll see people in 2 weeks.
That's right.
Have a good
Thanks
holiday.
very much. Bye-bye.